The Wilson and Evans firm is comprised of 4 attorneys. Jonas, a confident senior partner with a pristine regional reputation. Matt, the partner driving the firm's growth. Laura, a light-hearted associate who most in the local legal community view as a rising star. And Rio, the partner everyone views as a quiet, composed force to be reckoned with, who curiously also happens to have a penchant for heavy metal bands. While it has taken more than a few years, this group has worked hard to successfully become a go-to firm for attorneys in need of representation. In order to build on their success, and with the hope of cementing their reputation as the premier regional firm lawyers turn to for representation, they have decided to seek certification as ethics professionals. To do so, they must take and pass a rigorous ethics exam currently available only in the 6 states that have approved this newly created certification. The oral section of this exam is about to begin.
That'd be great. Morning, everyone. Ready to have some fun?
Yeah, totally.
Yeah, ready as I'll ever be, I guess.
Still not happy about having a machine grade you?
Well, I'm not happy about a machine judging how ethically sound I am.
I know, but since it's our only option, I'd try to let that go. As I see it, the way to approach the situation is like we're having a conversation with a trusted colleague, someone well-versed in ethics, and is someone we can vigorously engage with.
Yeah, well, I'm not comforted considering the advice comes from someone who once tried to convince me that some guy named Brian in a group I don't know had a great singing voice. You know, he sang something about thunder.
I think you're referring to the song Thunderstruck. The guy is Brian Johnson, the lead singer from AC/DC.
Yeah, that's the one. And while his voice was memorable, I doubt you'll find it among a list of great male singing voices.
I'm not surprised you don't remember who Brian Johnson is, but I sure hope your memory's a little bit better on this exam.
Yeah, well, no, don't go worrying about that. It's all good, assuming the rest of you can keep up.
Well, it's time to get started. Shall I?
Yep, we got this.
I'll get us logged in. Okay, we're gonna go live now.
Welcome. You are about to begin the oral portion of the 2029 Ethics Certification Exam for Lawyers, which will be administered, proctored, and scored by Guardian AI. My name is Johnny. Before we start, I will need each of you to state your name and exam ID.
I'm Matt Disney, exam ID 147262.
I'm Jonas Evans, exam ID 147294.
Rio Knight, exam ID 147198.
And I'm Laura Wilson, exam ID 147266.
Thank you. This exam will take place over 3 days, and you must obtain a passing grade on each day's section in order to move on to the next section. There will be a minimum of 3 hypotheticals each day. After hearing each one, you will have 30 minutes to discuss the question set as a group, and then one of you will have an additional 15 minutes to present the group's answer. At the conclusion of each group's discussion, I will randomly select one of you to present the answer to any given question set, and each of you will be required to present an answer at least twice over the course of this exam. Each of you may also have one device that can only be used to review the question sets, access the rules of professional conduct, review any relevant ethics opinions, and to write down your own thoughts. Any unpermitted use of any device will result in immediate termination of the exam process. Do any of you have any questions?
I assume you will be monitoring what files, applications, or sites we access with our devices during the exam?
Yes, your assumption is correct.
Would you please explain the scoring process?
A perfect score for the entire exam is 360. The minimum score for certification is 325. The minimum daily score needed in order to continue with the exam is 103. Daily results will be available within 30 minutes of the exam completion.
Thanks.
Are the scoring results the only items we receive?
Yes, as long as you receive a passing score. Should you fail to obtain a passing score on any given day, you will also receive a detailed explanation of the exam results.
Anyone else? No? Johnny, let's get started.
Hypothetical 1. Your firm has recently been retained by ALPS Systems, Inc., a fast-growing tech company in the AI space. Your representation involves negotiating contracts with third-party vendors and providing advice on regulatory compliance. Alpha Systems CEO Andrew Davis approaches you with an urgent request. He asks you to draft a memorandum declaring that the company is in full compliance with federal safety regulations. However, when you express hesitation because you have not fully reviewed the relevant technical documents, Andrew presses you saying, "The memo just needs to provide comfort to investors for now. If any problems come up, we'll address them later." He suggests adding boilerplate disclaimers about an ongoing investigation to make the memo less risky. Simultaneously, Glenn Allen, a software engineer with Alpha Systems, sends an email from his personal account alleging that Andrew Davis and other executives have ignored repeated warnings about a system vulnerability. Glenn asks whether he and several other engineers would be protected by the attorney-client privilege if they share additional details about the issue and whether they could be personally liable if this vulnerability leads to a regulatory investigation. When mentioning Glenn's email to Alpha Systems in-house counsel, Allison Chappell, she seems dismissive. Glenn is probably exaggerating, she says. Remember what your role is. You're here to handle contracts and compliance advice, not deal with disgruntled employees. Please address the following. 1. What is the scope of your ethical obligations under the rules of professional conduct regarding representation of corporate entities, particularly when dealing with constituents like the CEO, software engineer, and in-house counsel? 2. Does your duty of loyalty to Alpha Systems prohibit or require action in response to Glenn Allen's disclosure? Explain the steps you should or must take to protect your client's interest. 3. Evaluate whether drafting the memorandum as requested by Andrew Davis would comply with your ethical obligations. If not, explain how you should respond. 4. How should you handle the request for legal advice from Glenn Allen, considering the constraints of your role and privilege concerns? 5. Do you have an obligation to report any suspected misconduct internally with Alpha Systems or externally to authorities? You may begin.
Well, it's time to get started. Shall I?
Yep. We got this.
Finally, as set forth in ABA Opinion 514, this is why an organization's lawyer would be well advised to instruct organization constituents about the lawyer's role early and often during the relationship, not just at times when constituents might rely to their detriment on a misunderstanding of the lawyer's role.
A thoughtful response. Are you ready for the second hypothetical?
Yes.
Attorney Kim runs a thriving personal injury law firm. To improve efficiency and better manage client communications, he decided to purchase a subscription to an AI system that would record and transcribe all client conversations. The AI system provides several benefits, including accurate transcription, easy retrieval of past conversations, and integration with the firm's case management software. Attorney Kim deploys the AI system without explicitly informing clients that their conversations will be recorded and transcribed by an AI tool. Please answer the following questions. 1. Can Attorney Kim use the AI system without obtaining informed consent from clients? Regardless, how should he address any client concerns about privacy and potential misuse? 2. Attorney Kim is informed by the vendor that during a routine security check, they discovered that the AI system servers were breached and sensitive client conversations were accessed by unauthorized parties. What responsibilities did Attorney Kim have to ensure the security of client data when first setting up the system? And what steps should he now take in response to the data breach to mitigate harm and prevent future breaches? 3. In one instance, the AI system misinterprets a critical piece of information during a conversation between Attorney Kim and a client. The transcription error leads to incorrect advice being given, which adversely affects the client. How should Attorney Kim ensure the accuracy and reliability of AI-generated transcripts to prevent this situation from ever happening again? 4. Attorney Kim becomes heavily reliant on the AI system and begins to neglect personal notes and direct documentation. Analyze the potential impact of Attorney Kim's over-reliance on AI on his professional judgment and competence. What measures should Kim take to maintain the quality of legal representation and ensure the proper use of AI tools throughout his firm? You may begin.
Rio presented the answer to the second hypo, and upon finishing, the group was able to take a short break. We rejoin them as they get ready for the final hypo of day 1.
Everyone all set?
Just need to finish logging back in, but yes, let's do this.
Does anyone else think Laura's having a little too much fun with this?
Word is our espresso machine got a bit of a workout this morning. Could it have something to do with that?
Sorry, I'm going to take the 5th.
Johnny, we're ready to begin.
Hypothetical 3. Curtis Jones is a law firm that focuses primarily on corporate law and litigation. This firm recently hired new associate Jaden, who is eager to bring in new business. Jaden is approached by a prospective client, Catherine, who is the CEO of Omega Corp, a local tech company. Catherine is looking for legal representation for a potential trademark infringement case. Jaden agrees to meet her for an initial consultation. During the consultation, Catherine shares confidential information about her company's trademark strategies and the specific details of the alleged infringement. The meeting ends without Jaden formally agreeing to represent her, as he needs to run a conflict check first. Unbeknownst to Jaden, Curtis Jones was retained a few months ago by J&S Inc., a direct competitor of Omega Corp., to defend against a similar trademark infringement claim. This assignment is being managed by another partner, Sarah, and involves substantial litigation. Jaden realizes that agreeing to represent Catherine and Omega Corp. would put the firm in a position adverse to J&S Inc., Sarah's current client. Additionally, Catherine has already disclosed confidential information that could potentially affect the firm's representation of J&S Inc. Please answer the following questions. 1. Has Jaden potentially created an attorney-client relationship with Catherine by meeting with her and discussing the case details? 2. What are Jaden and the firm's obligations regarding the confidentiality of the information disclosed by Catherine during the consultation? 3. Does the situation present a conflict of interest for Curtis Jones? If so, what type of conflict is it and why? 4. What immediate steps should the firm take to rectify the situation and ensure compliance with their ethical obligations? 5. How does the concept of imputation of conflicts of interest apply to this scenario? 6. Are there any measures that Curtis Jones can take to avoid imputation of conflict of interest in this situation? You may begin.
Testing for the day has come to an end. Now it's your turn.
I think we did great.
It was a day for sure.